Good afternoon. Attorney Protective would like to welcome you to today's webinar, Check Please, Ethical Billing Practices to Avoid Fee Disputes. In order to comply with CLE requirements, we will not be giving formal introductions today. Please reference your materials for information about today's speakers, Erik Crep and Erin McCartney. With that, I would like to introduce your first speaker, Erin.
Thanks so much, Kate, and welcome everyone. And thank you for joining us today to talk about ethical billing practices and how to avoid fee disputes. I think most of us joining the webinar today would agree that no one likes dealing with bills. We don't like sending them, and we certainly don't like getting them. I know I especially don't like that uneasy feeling of opening a bill from a vendor when I'm not really sure what the price tag's going to be. I don't like that initial feeling of uncertainty, and either do clients when they receive their legal bills. Before we dive into the discussion on ethical and unethical billing practices, I think it's important to remember that when a client hires a lawyer, they're usually doing so out of necessity. So whether they're being sued and they need a really good defense team, or whether they're beginning the process of a tough divorce, whatever the representation entails, a lot of clients are coming to you in a vulnerable state. So they're willing to spend their money to get out of a bad situation or retain the best attorney they can afford. Some lawyers are only too happy to oblige, billing clients for every minute worked and then some in some cases. But is it ethical to charge a client more than $1,000 an hour of legal advice? If you're on a flight for 3 hours traveling for client A, but while in flight you're working on an oral argument for client B, can you charge 3 hours for travel to client A and also 3 hours of prep time to client B? Can 3 hours really add up to 6 hours of billing? These are all some of the things we'll be discussing today. Erik and I have seen a lot of malpractice cases in the course of our profession in which lawyers found questionable ways to squeeze money out of clients. Some are legal, but maybe in that ethical gray area, but would most likely make a client's blood boil if they found out. And the economy is struggling right now, so we're seeing more clients slow paying their attorneys, needing payment plans, or not paying their legal bills at all. So learning some new skills around legal billing may help you face some of these challenges. Our focus today is going to be on some best practices for ethically billing and getting your bills paid without getting sued. We're going to provide you with some guidance on how to implement billing practices that can actually cultivate strong, positive attorney-client relationships. And with that, I'm going to turn it over to Erik to talk about the ABA model rules on fees. Erik?
Thank you, Erin. I'm going to start the presentation talking, as Erin said, about the ABA model rules and the fees. And Model Rule 1.5. Now, every state has a similar, if not the same, rule with respect to Model Rule 1.5. So if you have a specific question, look at the model rules, but also look at your state rules, right? And the first part, the most important part about the Model Rules 1.5 is the position that attorneys cannot and shall not make agreements to charge unreasonable fee or an unreasonable amount of expenses, right? It has to be fair. It has to be moderate, right? It has to be what is reasonable and fair. And I'm going to have some examples of that as we go through the presentation. So number one, right, the time and the labor required and the novelty and the difficult issue involved and the skill is a factor, right? One of the factors to determine whether or not the fee is reasonable. So examples, right? A trip and fall case or an automobile case is obviously different skill, different difficult question than an antitrust lawsuit or a patent lawsuit, right? Medical malpractice, different from a general liability, international issues in federal court versus auto accident, criminal case, all of that factors in to determine whether or not the fee is reasonable based upon the time, labor, and the novelty of the question. Number two discusses whether or not the employment will preclude you from employment for other clients, right? So if you are being asked to take on a case that is going to take up all of your time for the next month, that rate can potentially be different as long as the client approves, and we'll get into that, than if it's a case that's going to be the normal course of 18 months to 2 years. Number 3 is the fee that is charged in the locality that you're in and what is similarly charged for legal services, right? So New York City, I assume different than the middle of the country, different than San Francisco, LA, right? So where you are is a factor to determine whether or not it's reasonable. The amount involved and the results that come from the case, the time limitations imposed by the client, that kind of gets into one of the prior topics, right? Is it a rush case where we have an appeal and we have 2 weeks, or is it a normal case where you're going to have the 18 months or 2 years? The number 6, the nature and length of the relationship with the client, and then number 7 is the experience, the reputation of the attorney, and the ability, right? First-year lawyers, associates don't have the same rate as a 20, 25-year board-certified attorney, right? That would not be reasonable to charge a client the same amount for the senior partner versus a first, second-year lawyer that just came on board, right? So all of that is important and part of Model Rules 1.5a. Now, in terms of examples, right? Obviously, a lot of this I think is common sense, but common sense is not so common, right? So you have to think of, and I'm going to give a couple of examples of either fees or costs that are not reasonable, right? So for example, mileage reimbursement, right? You're allowed to get reimbursement for your miles. I would say the standard of care and the reasonable amount is what the IRS allows for mileage, right? And you have to be accurate on your miles amount, right? If I'm in Miami, if I'm going to Fort Lauderdale, I think it's 31 miles maybe to get there, maybe less, but I can't round up and say I'm just going to charge them 50 miles, right? You have to be accurate, right? You have to be detailed because it might slip through, but that would be unethical, and eventually it's not going to, right? Another example is billing 2 clients for the same at the same time for the same trip, right? This is maybe a little bit different if you're still doing Zoom hearings, but if you're going to a courthouse and you have morning calendar or morning motion calendar and you have two arguments, right? Same judge or different judge, you can't bill 2 separate clients, travel to the courthouse for client A and then travel to the courthouse for client B. Argue the hearings and then bill double backwards, right? You have to bill one or the other. What I do is one client gets charged for travel down, the other client gets charged for travel back, right? Copy costs, excuse me, is another example. Make sure you're not overcharging for copy costs, and then double billing, right? That's key. I've seen this many times. You're traveling on an airplane, non-active, so you're not driving on an airplane or on a train for those who live in areas where there's trains, and you're billing for your train time to travel to location but working on another client at the same time. That's not allowed. That's against the model rules and against the standard of care as well. A couple case examples, right, where courts who have to approve the fees have said this is not a reasonable fee, right? And sometimes you don't think about it, right? You're like, well, that seems reasonable, right? So there's a case, I forgot where the jurisdiction is. It's a paralegal had to deliver something to the courthouse, right? And it took her like 2 to 3 hours to deliver it, and they charged the paralegal rate, I think it was $180 per hour, right? The judge didn't allow that fee, said it was unreasonable because said you should have either used FedEx or a courier, which would have cost $50 versus $600, right? So little things like that are not reasonable, right? Another thing is hours per day, right? There's a bankruptcy case, I forgot what jurisdiction, where the lawyer who represented an athlete proposed a $2.6 million fee. And they proposed and billed 7,200 hours over a 10-month period, which would equate to about 24 hours a day for 300 straight days. The court said, well, this is unreasonable, right? This is reduced, right? And we're also reducing some costs because one thing that they tried to include was air conditioning fees on the weekends, right? Some buildings, I know ours doesn't have air on Sunday. If you want air on Sunday, you got to pay for it. That's not something you can reimburse and send to the client. Also, there's another case where an attorney billed 5,400 hours in 1 year total. That is just, I don't even think that's possible. Another example that I want to talk about is billing too much for the case at hand, right? So you can certainly bill for filing and doing research on substantive motions, motions in limine, motions for summary judgments, novel issues, or case-specific issues. But you can't bill to educate yourself on something that a lawyer should know, right? And there's a case in Oklahoma where the court reduced the fee because the attorney tried to bill or did bill more than 500 hours for work that the judge deemed was an unreasonable amount because it was a simple, straightforward Fourth Amendment excessive force case. And the attorney billed, for example, 19 hours for research on well-established 11th Amendment defense issues, right? And 49 entries for discussions with co-counsel. That was unreasonable, and the judge said that the lawyer's inexperience resulted in the counsel using the litigation as an educational forum in the area of civil rights law. So be careful taking on cases that you don't know the law, because if you have to learn it, then if it has to be court approved, the courts may not approve it. A couple other examples, and I'll move on to some of the other topics. There's a case out of Illinois that talked about, I think it was a probate case, where the lawyer said, I'll either charge you $175 an hour or 1/3 of the amount recovered. I think it was a probate case for legal services. The recovery was $450,000 in assets, and the client chose contingency fee, but because the entitlement to her asset was never at issue, the court ruled that this minimal amount of work didn't warrant recovering 1/3 of the $450,000, which was $148,000 and change, and instead ordered that the hourly rate be charged. So, you know, in sum, I think, at least when we're talking about our model rule, A is make sure you bill for only your work, be mindful of the expenses, don't overbill, and I know Erin's going to talk about it a little later, but, you know, bill how you want to be billed, right? Don't double bill. I think I missed a slide. Don't double bill. Don't upcharge or round up your numbers, right? If something took 45 minutes, it took 45 minutes. You don't round up to an hour, right? Especially deposition transcripts. I've seen other lawyers lose clients because they inflate the deposition time when there's a transcript that logs the start and end of the depo. So be mindful of that. Rule 1.5b, retainer agreements, right? The scope of the representation, the rate of the fee, the expenses. It should be in writing, preferably in writing. I say it should always be in writing because I think once the client and you have an understanding of what the retainer agreement says, what the charges are, whether you can bill for a senior partner and an associate at certain events, and also the cost of subpoenas, medical records, paralegal rate, if there's out-of-town depots, flights, meals, all of that should be set up in the retainer agreement so that the client isn't surprised. Make sure you update your agreement and make sure your retainer agreements, this is a little bit outside of the scope of billing, but make sure that they have the scope of the representation, right? Because you don't want to have it so wide open that your scope is beyond what you're really retained for, right? So if you're retained on an immigration matter to file the application and represent the client at a hearing, but not do any of the appellate work, make sure that's in the agreement, right? That all gets down to billing so that you don't have to do something that you're not used to. And the best practice, again, is to keep it in writing, do it in writing, even though the model rule doesn't require it to be in writing for 1.5B. Also, I think in terms of retainers, it's important to also put in there things about the right to withdraw, the right for the client to terminate, again, how things are billed, how things are charged, the cost, outside costs, all of that should be included in the retainer agreement. With respect to 1.5C, right, these are contingent fee agreements, plaintiff lawyer agreements, right? This is different from the retainer agreement of 1.5B because these shall be in writing, right? They always have to be in writing, always have to be signed by the client, and then shall state the method in terms of how the fee is determined, right? I know Florida, it's set by the bar rules. There's a different percentage amount if it's in pre-suit, if the case resolves before an answer is filed, and then if it goes into litigation and appellate fee. All of that should be set forth in your retainer agreement. In your fee arrangement agreement, and that includes expenses, right? And when expenses are deducted, right? They're deducted from the top, and then the fee comes out, right? That is important to have. Model Rule 1.5D talks about agreements that a lawyer shall not enter into, right? And how you don't enter into an agreement. And number one, if you do family law, divorce law, things like that, you can't have your fee contingent upon securing a certain amount of alimony or property settlement or full custody or more money. It can't be set up where it's based upon you getting more from the other side, right? In a contingent fee for representing a defendant, right? It can't be, you can't have a contingency, for representing a defendant in a criminal case. So you can't say, well, I'll charge you X if we plead guilty, Y if we're acquitted, and Z if we go to trial and lose, right? And number E, 1.5E, it talks about a division of fees between lawyers in the same firm can only be made, what it says here, confirmed in writing, and the client agrees, right? No side deals, no handshake deals, things along that line, right? And these are strict requirements, right? Referral fee agreements, right? They need to be signed, right, by the client. If a lawyer, refers the case to the lawyers handling the case, it needs to be signed by the client so that they are informed of the lawyers involved and how the fee is split between the active lawyer, I'll call him or her, versus the lawyer who referred the case, right? The clients must consent and the total fee must be reasonable, right? You also can't have referral fee agreements on your contingency cases with non-lawyers, right? A neighbor, chiropractor, college friend, tow truck driver, like they don't get referral fees under the model rules, and I think under most states, if not all states, right? So can't do it. It has to be in writing, which is why the client needs to sign off on it. And I think at this point, I'm going to pass it back to Erin, who's going to talk about avoiding fee disputes.
Great. Thanks, Erik. And great job covering the rules. And as Erik said, the client doesn't want any surprises when it comes to their bill, but you also don't want any surprises when it comes to your client. So let's look at intake procedures and more specifically how they can help avoid billing issues down the road or even dealing with a problematic client. I think all too often attorneys want to practice law and not deal with the operational part of running a law firm, but your client intake process is often your client's first experience working with you and your staff. For your new clients, the intake process can either validate or invalidate their decision to work with you. So don't miss a great opportunity to improve your law firm's performance by doing a bit of work on the intake process, and it could yield some long-lasting benefits. So ask yourself, when a client comes into the office, what are the typical intake procedures of the firm, and are they working? So taking time, I think, at the front end to do certain key things during new client screening and intake, it can give you more certainty that you're going to be working with reliable clients and getting paid. So what are some of these key things? Well, you'd want to have a standard potential client intake form with a template of questions that elicits the information that you need for client screening. I'm a big fan of using forms as a starting point for things like client intake, engagement, and disengagement letters, as well as fee agreements. One size may not always fit all, but I think forms are a great place to start to be sure that key things aren't forgotten. Forms are also a great starting point for the client interview. The Florida Bar Association has a really good initial client consultation interview form on their website, and I think that this one can be a great launching pad for the development or the refinement of your own. And you'll see that listed on the slide. But let me just quickly walk you through some of the things that it contains. It has this great lead-in paragraph about the purpose of the initial consultation. It says, the purpose of the initial consultation is for the attorney to advise you, the prospective client, what, if anything, may be done for you, and to assess what the minimum fee, therefore, will be. The purpose is not to render a definitive legal opinion, as it may be impossible to fully assess a matter within the time frame allotted for a consultation, or with the information or documents that you may be able to provide at the initial consultation. It also advises one of three outcomes is possible following your consultation. 1, you and the attorney mutually agree on the terms of the representation. 2, the attorney declines the representation. Or 3, you decide not to use the services of the attorney. These upfront explanations clearly set expectations out of the gate. I also really like the section that says, knowing that there are no guarantees, what can you accept? These questions really get the potential client thinking about how they see their matter moving forward. Another great question on the form asks, if the matter involves payment of money you feel you are owed, how long can you wait before not getting paid? Days, weeks, months, years? I think this is a really important question. If they write, I need it tomorrow because I'm flat broke, you should start seeing maybe some red flags. Do they have money to pay their bills? Another great question is about prior representation on the matter. Don't you want to know if they were fired as a client by another attorney? I actually handled a case where I could not understand why the firm took on this client. By the time the firm I was defending was hired, the client had already been represented by 3 other law firms and had sued 2 of them. Not surprisingly, she decided she was not happy with my lawyer's services either, and then ended up filing a malpractice suit against the firm and refused to pay any of the legal bills, which at that point had added to a significant amount. Do you think the firm should have taken on this client? Should they have been surprised when she did not pay any of her bills and then turned around and sued them for legal malpractice? Probably not. So keep in mind, it's a huge red flag when a client is changing lawyers in the middle of the case. It's even a bigger red flag when they're suing former lawyers for legal malpractice. They're either trying to avoid paying their legal bills, or they may be very difficult to satisfy. But either way, you may not want them as a client. So use this intake form to gather information to properly screen a potential client. We also have some great resources on the attorneyprotective.com website under Protect Your Practice. So if you are looking for different resources, that's another great place to look. Okay, so once you've reviewed the form, there should be a face-to-face interview. And during that interview, you should learn more about your client's issues. Some you may be competent to handle, and others you may not. And Erik touched upon this a little bit already. Remember that doctors send patients to other experts when something is outside their scope, and so should lawyers. This is also when you have to be honest with yourself and your current caseload. Do you have the time and resources to properly handle this matter? Make sure you know the rules of professional responsibility within your jurisdiction and the obligations you have to your clients. Be mindful of your duties to the client, as well as the client's rights, such as the right to be promptly informed of all developments, and then make sure you can adhere to them. If you're a small firm and anticipate being inundated with documents, depositions, motions, should you take the case? You could miss deadlines, or not have time to communicate with the client. And this could result in the client refusing to pay their bill. They're angry. They feel neglected. Also, use your instincts when accepting a client. Take adequate time during the initial interview to develop a feeling as to whether the client will be a problem. Do they have unrealistic expectations? Are they truthful? Are they cooperative? Does the potential client seem extremely disorganized? This can not only be extremely frustrating while representing them in their matter, but it's a pretty good sign that they're not going to pay your bill because it's either been misplaced, accidentally thrown away, or they're so frazzled they've completely forgotten all about it. Another type of client that can be a potential problem when it comes to paying bills are those who nitpick or are difficult to satisfy. If the potential client seems particularly nitpicky about things, well, there may very well be a good chance that they're not going to be pleased when the representation comes to its conclusion, and they may use this as the reason to not pay their legal bill. You should try to make an assessment up front as to whether a client can afford your services. There are several approaches to determining if clients can afford fees. Giving a client a reasonable estimate of fees and expenses and then judging the potential client's reaction can help avoid problems down the road. If your first reaction to discovering a billing problem with the client is, I knew this client was going to be trouble, or I knew I shouldn't have taken this case, you probably need to do a better job screening potential clients. So, in summary, some red flags that a client could burn you on billing would be changing lawyers in the middle of a case, trashing the lawyer they just left, reluctance to answer basic questions, providing inconsistent or incomplete information, and then also wanting to use the legal system as a weapon of revenge or retribution. So be smart, don't ignore red flags or that gut feeling telling you not to take on a client. Remember, you have the choice not to take a case. If you're looking for more tips on client screening, there is an article called Spring Cleaning, and it provides more tips on client screening on our website too. So moving on to intake procedures and more specifically letters. Okay, so after the initial interview and checklist, you decide to represent the client. Once you've decided you can and will accept them as a client, you'll need to translate your agreement into an engagement letter and a fee agreement. Obviously, the scope of an engagement letter is much broader than just fees, but today I'm just going to address the fee aspect of it. So you've already discussed the fees during the client intake process, so it should be pretty easy to reduce the understanding to writing. The agreement should be straightforward and understandable. If there was not a clear understanding about the fees and expenses up to this point, it should be clear now. Keep in mind, many disputes between lawyers and their clients are about money. Erik and I can definitely attest to that. So the engagement letter should set the attorney's fees, associated costs, and how and when the client will pay straight. Because if there is a dispute down the road, the agreement can assist in fee retention. A written contract forces both parties to be very clear about what they expect of each other. The engagement letter also can assist in managing risk arising from legal malpractice and disciplinary liability. So what should the engagement letter have to ensure that you're not running into billing issues in the future? It should specify the name of the client. It should include the fee arrangement and expectations for payment. How much will it cost to achieve the intended result? If it's a contingency, you want to clarify what cost the client will be expected to pay. If it's hourly, you want to prepare an initial budget. Also, keep in mind, generalizations can get you in trouble. So also set forth detailed scope of professional services to be provided, as well as services the firm is not providing. And I think Erik touched upon this a little bit earlier, too. I've handled many legal malpractice claims, and a lot were filed simply to reduce legal fees. But when the bill is so general, it makes it more difficult to defend. I saw things like 50 hours spent on case X, Y, and Z at $400 an hour. You owe $20,000. Please pay immediately. The client deserves to know what you spent your time working on, and this is why itemized accounting is a good idea. Where exactly did those 50 hours go? If you claim that you wrote a letter to opposing counsel for 4 hours and the letter turned out to be 2 paragraphs long, your client has a right to seriously question your time management. Itemized accounting helps keep you honest, too. So the engagement letter should also include important dates and potential benchmarks, and then outline the responsibilities of the attorney and the client. And I think this one's really important when it comes to avoiding potential billing issues. So explain the process, what is expected of your client, as far as document production, interrogatories, depositions. Explain settlement versus trial, experts and other expenses. How long will it take until resolution? If you're upfront with the client about what's expected of them and what's expected of you, and you have it in writing, if there is a fee dispute at a later date, you have this agreement to hang your hat on. If the scope of the representation is questioned after the fact, you're going to be in a much better position to substantiate your version through the engagement letter. This same principle applies to non-engagement and disengagement letters. You're going to see on the next slide, when we're talking about engagement letters, I always think it's important to quickly address non-engagement and disengagement letters, because I get asked a lot about whether a firm should incorporate disengagement letters into their practice. So, number one, I absolutely recommend that lawyers incorporate closing and disengagement letters into their practice to help clearly communicate that the representation has concluded. Disengagement letters also provide a powerful evidence of the date the attorney-client relationship terminated. Essentially, closing letters transform current clients into former clients for the purposes of avoiding conflicts with other prospective clients. The absence of a disengagement letter has contributed to the filing of legal malpractice claims by persons to whom the lawyer believes they no longer owed a duty. A common legal malpractice scenario that I've seen is that without a disengagement letter, a client later alleges that the attorney failed to follow up on a case before the expiration of the statute of limitations. So think, without a definite termination date, the statute of limitations for a malpractice claim can effectively cease to begin running. So lawyers should use disengagement letters because disengagement letters can provide attorneys with the level of comfort that the client understands the representation has ended and that the attorney is no longer responsible to safeguard their interests. The disengagement letter can be short and to the point, but it should make clear that the representation has ended, and it should include the date of the termination. Firms can also use a closing letter to remind the client of the firm's document retention and destruction policy. They should also use it as an opportunity to reinforce the quality of their work and encourage the client to look to them for any future legal needs. So, again, there's some great forms for all of these letters available online, and you can use them as a template to tailor them to your own firm's needs. So moving on, you will see there's a sample non-engagement letter in the PowerPoint, just because as a risk manager, I get asked this question a lot, and I always get asked, can I provide a template? So I just thought it would be important to share here. And again, you can find some on our site as well on the Attorney Protective website. So moving on, let's talk about intake procedures and clearing the smoke and mirrors. On clearing away smoke and mirrors, I want you to stand in your client's shoes just for a minute. I think as a consumer, we expect a level of certainty when it comes to services or products that we purchase. Whether it's a monthly credit card statement, a plumbing bill, or whatever other invoice I receive, I want an itemized list so I can go through each item and confirm that they are legitimate charges. Clients want this too. So think, does your client really understand how expense items are generated? For example, if you're handling a case in another county, there may be additional expenses associated with that. Does your client understand that? So provide itemized billing, which we just touched upon, but also make sure that you review them for errors. All associate bills should be reviewed by a partner before the client is billed. Look for errors such as double billing, which Erik talked about, charges on the wrong file, and also if the amount of time spent on a particular task is reasonable. It would also be a good idea to compare the bill to the fee agreement that you and your client agreed upon in the beginning of the representation. And then be sure that you're not charging or overcharging your client for any items that were not listed in the fee agreement. You also want to avoid vague billing descriptions. Complete, detailed, and accurate task descriptions are the easiest way to prevent a client from flagging your bill. Every task description should identify the activity with sufficient detail to assess its necessity and its relevance to the case. Along with a detailed description of the task, each time entry should include the date the task was performed, the timekeeper who performed it, and the time spent performing the task and the total fee. Your client may question why you billed 45 hours reviewing and revising a brief. but perhaps the brief was really long and it involved multiple complex issues and extensive research. Whatever the reason, vague terms like review and revision, they do little to inform the client why the review merited a week's worth of time. Simply giving the client hourly rates, it doesn't really give them the full impact of the cost of the services, especially in more complicated matters. Estimating the full cost of the representation helps the client understand how expensive the matter may be. Make it clear that you must be paid regardless of the outcome and that there are downside risks to litigation. Clients who are more fully informed about costs and the risks are less likely to complain about fees. As we stated earlier, all fee arrangements should be in writing. Combining fee arrangements with engagement letters, specifying work to be done, it's a very efficient way to assure that communication about fees are in writing. And then keep in mind that a well-informed client is likely to pay their bills, so routinely connect with your client. You want to make sure you're billing at regular intervals. Return calls promptly or provide office hours. That would be times when you can make yourself available for client calls. Keep the client informed of changes in evaluation and put it in writing. You should update your client when there's a change in evaluation or the budget, and do it as soon as possible and explain why. Hey, did the evaluation change due to an expert report? Did your client or the opposing party perform better or worse at a deposition? Did a witness come forward to support the opposition? Do these new developments change the course of action and therefore the budget? Communication with the client, it's not something that lawyers should just consider at the beginning of the representation, but it should be considered throughout the life of the case. And as the case progresses, provide clients with documents which have an effect on their prospects for success or failure in the litigation. And discuss any developments which either increase costs or decrease the likelihood of success shortly after they occur. And then provide the client with a new estimate of costs in writing as the case continues. Really, the bottom line is you just want to take any guessing on the client's part out of the billing equation. Requiring a retainer and requiring that a client replenish it on a regular basis provides a way to weed out those clients who are less likely to pay when the bill comes due. And as the case progresses, talk to the client as soon as the bill goes unpaid or the retainer is not replenished as agreed. Certainly, there's going to be situations where a lawyer may consider floating a client for a short period, but it's common for clients to fall behind and then never catch up. And it's best to withdraw before a bill grows even larger. Withdrawal becomes more difficult as litigation or a transaction approaches conclusion, and we're going to touch upon that in just a minute. But before we do, let's move to the next slide. Withdrawal for non-payment. Can a lawyer withdraw from representing a client for failure to pay their legal bills? This is another question that I get asked a lot about on our risk management hotline. The general rule is that a lawyer may withdraw from representation when a client refuses to pay the attorney for services in violation of the fee agreement, or if the representation causes the lawyer financial hardship. This general rule holds true so long as the withdrawal is not materially adverse to the client's interests. Despite best efforts, some clients still may not pay their legal bill. Some precautions to help mitigate the risk of non-payment include using adequate retainers and flat fees since you take the money up front. The fee agreement should set clear expectations for payment and the consequences for the client's late payment or their failure to pay. Will work stop until the account is current? Will the client be charged interest? State in your retainer agreement that non-payment is grounds for withdrawal. Utilizing these types of provisions in the fee agreement can help avoid situations in which you're contemplating withdrawal for non-payment of fees. Best practice tips regarding withdrawal for failure to pay legal bills. Number one, the first step to avoid being in a position in which you need to withdraw due to non-payment of fees is to determine upfront whether a client can pay their bills. This is why thorough client screening is so important. Keep in mind that non-payment is not a defense to non-performance in a legal malpractice action. So a lawyer seeking to withdraw for non-payment should take reasonable steps to provide sufficient notice to the client so that substitute counsel can address pending motions or prepare for trial. And finally, be sure to avoid disclosure of any confidential client information. Next, we're going to move on to 7 billing tips. Number one, and probably the most important one, happy clients don't sue, and they generally don't complain about the bill. Believe it or not, there are plenty of clients out there who are thrilled with their lawyers despite them not having gotten the best possible outcome for their case. So maybe you ask, how is this possible? It all comes down to a positive client journey. Once you start adopting the mentality that each stage of the client journey is an opportunity to delight, then you start transforming the way you run your practice. Where many lawyers fail to delight is with client communication, and I have seen this time and time again. Keep in mind, if you fail to return repeated phone calls or emails, you may not get paid, but you also may be violating your ethical responsibility of communication. If you are busy working on another case because of an impending trial or tending to a sick relative, let the client know about this. Most clients will understand and will appreciate the honesty. Again, I think it's about setting expectations so the client is not feeling neglected or ignored at all. Developing a strong client relationship can pay off in the long run. This means you have to listen to them as much as you talk, doing simple things like asking open-ended questions, like finding out how they want to get information from you. You can say, this is typically how often I report. Does this work for you? Or what form of communication and reporting would you like? Let them feel like they're part of the process. Next, let's talk about sticker shock. If there is going to be a big bill or other negative news, give the client a heads up. Communication is key to invoicing success. We are going to talk about more client communication in just a bit, but when it comes to managing the client relationship, if you've noticed that your invoice in a billing period will be way off course from your client's expectations, don't ambush them with a terrifying invoice. Pick up the phone, give them a call, give them a heads up, and let your point of contact know exactly what's going on. I think deliver the bad news concisely, clarify the who, the what, when, why, all that good stuff, and add an explanation to the invoice so they don't have to try to remember that you already called them and you explained what was going on. Let your point of contact and the billing department know what's coming ahead of time. You also want to make the bill easy for them to pay, possibly offer online payment solutions. Online payments offer the client more options to pay, making it a lot more convenient for them to pay you. There was a recent study that I saw that showed that law firms are getting paid almost 40% faster by using online payment solutions. So that's just something else to think about. And then next, it never hurts to include a personal touch like a handwritten note or a client newsletter with a bill. Mail your clients birthday greetings and holiday cards. I read once the effect that a personal gesture has is usually proportionate to the effort it takes to make it. And I think this is so true. It takes time to write a personal message, but the gesture is usually remembered and appreciated. I think especially today when less and less firms are doing things like this, it's actually a really good way to stand out and be remembered. Next, bill immediately when you achieve a major milestone. This is another really important one. You want to tie items billed to clients' hoped-for results. Billing immediately when you've just achieved a major milestone in a case, it makes perfect sense. I think we have all heard the phrase, striking while the iron is hot. Well, usually achieving a major milestone is expensive, so celebrate the success with them and then send the bill before the euphoria is over. I think it's also a good idea to include the client's recent or previous payment on the invoice. I think this is a form of positive reinforcement that can go a long way. And then next, it's inevitable that there's going to be inefficiencies on a bill from time to time. Disclose inefficiencies and then write them off the bill. When retailers write something off, I always feel like I kind of won something. An unseen discount is worthless to your client. It's worthless to you. Even worse, bringing up a discount after the fact is far more likely to create resentment. Clients are more likely to assume that you're using discounts circumstantially to gain leverage over them. So make sure you get these brownie points when you are writing something off. The same goes for things that you weren't going to bill them for anyway. Go ahead, put it on the bill and mark it as no charge. You'll get those extra brownie points that always make you look good in front of a client. And then make sure you tie bill time to the client's hope for results. I think this sends a huge positive message that you listened to what they wanted, you did what they asked. And then finally, having the tough conversation, why aren't you paying the bill? Most risk management experts will tell you that it's a bad idea to work for a client for months without getting paid. I think common sense tells us this too, but more and more lawyers are doing this today. It may be driven by an optimistic or an unrealistic belief that the clients will eventually pay them, or it could be driven by the fear of having no clients in the wings to replace this business. So what do you do when a client's not paying their bill? Don't just keep sending them letters or emails. Pick up the phone and call them. The lawyer is often the best person to call, not just the billing clerk or the bookkeeper. So think about getting the attorneys involved when a client stops paying their bill. Also, as their lawyer, you or the lawyer involved, they already have a relationship with the client and hopefully talk to them on a regular basis. So if you're getting pushback from lawyers in your firm about helping out with receivables, maybe explain how better collections mean higher profit margins and more money without having to work those additional hours or raise rates. And then if necessary and possible, talk to the client about payment arrangements or details. On the one hand, you probably don't want to advertise payment arrangements as it may encourage clients to pay late or pay less. But on the other hand, it's something that can be used to encourage delinquent clients to pay versus dealing with write-offs or write-downs. If a client's not paying you, think about this. There's probably one of three reasons why. They have no intention of paying you, and therefore they're going to use any means they can think of to avoid paying you. That's the worst case scenario. The cost of the representation was more than they originally anticipated, and they're having a difficult time making the payment in full. This is the best case scenario. They may be embarrassed or they're avoiding you, but if this is the case, reach out to them. Try to put together a reasonable payment plan. The third reason may be they're mad. They're either unhappy with the progress of the case, they're dissatisfied with your work or your billing practices, or they're angry about the lack of communication. And not paying you is one way they're going to send you that message. So if the client is refusing to pay for part of the work or all of the work, investigate the matter further and try to determine if it was justified. Taking a step back, many clients are nervous about working with attorneys. Legal bills can exceed most other expenses. They can even exceed paying for a car. So clients may be confused by whether certain things are itemized, or they're concerned about inflated billable hours like some of the cases Erik was talking about. So you want to make sure you just have open and honest communication with them, because clients do have a fear that they're going to be cheated somehow, and you want to take that suspicion out of the equation. So with that, I am going to pass it back over to you, Erik, to talk about billing tips and avoiding fee disputes.
Thank you, Erin. Before I get into the topic of avoiding fee disputes, I just kind of want to add a little bit to what Erin said about 7 billing tips. And she talked about, vague billing descriptions, and you should not have vague descriptions. From my perspective, I think it should be as detailed as practical without writing a novel, right? So if you're preparing for a deposition of Dr. X, don't just put prepare for Dr. X, right? The client wants to know, what are you doing? So I would write something along the lines of prepare for the deposition of Dr. X, including review of medical records, portion of deposition of the plaintiff, or whatever it is. Give a little meat to the bone so the client knows what's going on, right? And I think the client should be able to look at your bills, right, and kind of understand the story and what's going on. Because the bills, in some respects, should tell the story of the case, right? It should tell the story of what's going on. Is there a hearing? Is it the deposition of so-and-so, right? Is there a meeting or something with the judge? So try to be more detailed and explain why what you're doing is relevant, why what you're doing is important to the case, and why it progresses the case in your client's best interest. With respect to the last thing before I jump back to getting on topic, Erin talked about write-offs, right? I think write-offs are great because, like Erin said, I think it gives the client the feeling that they are getting something from their lawyer without their lawyer billing for everything, right? Against their reputation, lawyers bill for every 0.1, right? And I think a lot of times what I do is when I'm talking to the client, I may put it on the bill, but I usually no charge it. Because you don't want your client to say, I don't want to pick up the phone and talk to my lawyer because he's going to charge me for it, right? Some things you have to charge for, right, if you're getting authority or talking about detailed, but if you're spending a good portion of the call just getting to know your client better and having a good relationship, don't bill for it. The clients will appreciate it, and it will mean a lot in terms of collecting the fee. So with that in mind, back to where I should be, avoiding fee disputes, right? Erin touched upon this, but if you're going to sue your client for money, past bills, past invoices, more likely than not, and probably higher than 51%, right, it's going to result in a counterclaim for malpractice, right? I've seen it on many cases. I know Erin has seen it on many cases. So you have to think thoroughly through whether or not you want to sue your client for a past invoice, because it's going to be a counterclaim for malpractice. So you have to analyze what's the cost of suing a client for fees when all things are considered, right? How much is the fee is a consideration, right? And then also, how is it going to impact you as a lawyer and you as a member of a firm if you practice in a firm, right? Years of litigation, depositions, discovery, getting content with respect to emails, the client's files, and then once you're sued, it's public record forever, right? So if a new client Googles you or goes to the courthouse website, they're going to be able to see my lawyer got sued and read about what the allegations are, even if they are not true, right? You can lose a client, obviously, if you're suing your client, and there can be negative press depending upon what it is. So there's a lot of things to consider when you're suing for fees, which is why you need to avoid fee disputes, right? And how do you avoid fee disputes? Along with a lot of the things that Erin talked about, you have to manage your receivables, right? Every business has a right to get paid, right? Contractors, store owners, restaurants, doctors, and yes, even lawyers, right? We have a right to get paid, right? So I think it's best to speak with your client, right? We're in the world where everyone does emails or instant messages or texts, but I think things get done, whether you're talking to opposing counsel on issues or talking to your client with picking up the phone, because more likely than not, the client is almost embarrassed that they haven't paid the bill, and they want to pay the bill. They want to make sure that things are being done, and that bills are being paid, right? But it's better to do that earlier than later, right? Because studies show that if you're 90 days or 120 days past due and that account still hasn't been paid, the likelihood of collecting decreases, right? Especially if the case is over and the work is complete. So try to stay on time with respect to billing and getting the bills paid. Some firms and some clients, right, will offer a little discount if they pay within 30 days, right? You can offer a 2% discount or any percent discount if it's paid within 30 days. Some clients automatically do it, right? So that's similar to a credit card fee or lack of a fee if you pay it earlier, right? And I think with respect to managing your receivables, right, you always want to bill as if you're the client, right? You want to bill as if you're the one getting the bill, and you want to deal with your client as if you're paying the bill as well. So that's why I think just picking up the phone and being honest, and like Erin said, striking when the iron is hot. If it's a good result, send the bill in and let them know we got a good result. Oh, by the way, the bill is going to be coming the next day or two, right? So in terms of the next slide with respect to paying attention to warning signs, right? Erin touched upon it, right? Not returning your calls, ignoring emails, not cooperating with the case, asking, why are we doing this on this case? Why do we need to spend money on this, right? Those are all warning signs of a potential client who is starting to think about not wanting to pay your bill and wanting to eventually probably have a dispute with you about the bill, right? If they're overly concerned about the fees or about the cost of something, if you have to fly to take a deposition, why we have to do this in person versus by Zoom, right? Sometimes you need to be there, right? So all of that stuff is important to pay attention to and potential warning signs to avoid fee disputes, right? But at the end of the day, right, listen to your gut and follow your instincts and look out for the warning signs because they're there, right? Don't put your head in the sand and avoid it and say, I'll call them next week, they'll pay the bill. The longer it sits there, the harder it's going to be to be paid. So with that, I'll pass it to Erin, who's going to talk about the last topic before we have some questions.
Great. Thanks, Erik. So I know we already talked a lot about the importance of good client communication and avoiding fee disputes, but I just want to highlight again, if you're honest about how much the fee could be, there is less potential for the client to feel surprised or betrayed on the issue later. If you're honest about the fact that, hey, unanticipated events, they can change the fee later, when it happens, they're a lot less likely to feel that you pulled a bait and switch on them. So just some good reminders are keep the client posted on the progress of the case and how it relates to their money that you're spending. Let the client speak. If they feel like they're being heard and they feel like they're part of the decision-making process, they're a lot less likely to be critical when things don't turn out as expected. And then I would just say that reliability is a really important piece. Did you do what you said, and did you get it done within the budget and timetable you said? I think as consumers, like Erik just said, we can all understand how important this is and how much reliability is valued. Remember, you want them to come back for any future representation needs. So getting it right on big things like billing practices, it means that you can ensure that future business. Again, as consumers, I think we can all relate to this. Certain good experiences, they keep you coming back to certain stores or certain vendors, while negative experiences has you write them off for good, or even worse, badmouth them to other potential customers. And that's what these clients will do to you as well. So just keep in mind that that works both ways for your legal reputation too. Finally, I just want to share with you on the next slide, I put a sample collection letter on there. This is also from the Florida Bar, and I think it's good, but I'm hoping you never need to use this. Before you engage in collections or a collection agency, I would recommend that after reaching out to the client to ensure that the client does not have a reasonable basis for non-payment, send a final demand letter. The letter should outline your rights as a creditor, their rights as a debtor, the specific time they have to make a payment, and the actions that you will take if they do not remit payment, such as turning their account over to a debt collection agency. However, keep in mind the client could respond with a malpractice claim, even as a mere defense mechanism to avoid paying the legal bill. Erik and I have seen this time and time again. So if the dollar amount owed to you is relatively small, it may not be worth your time to pursue. It may be, but it may not be. And these are the things that you really need to think about. So calculating how much debt to walk away from will involve the specifics of your situation. But again, doing the things that Erik and I talked about on the front end will hopefully avoid you ever being in this situation. Client screening being really important, staying on top of any bills that have gone unpaid, and making sure the communication is clear and honest between you and the client so you aren't chasing after those bills and find yourself in a position where you need this sample collection letter. So with that, I'm going to pass it back over to Kate to open up our Q&A. So Kate?
I'll first ask, is it reasonable to charge for time spent learning about an area of law you are not familiar with?
Erin, I'll add, I'll answer this one because I sort of touched upon it on one of my Kate's examples, right? So the short of the answer is no, right? I think, you're allowed to bill for, if you're in a novel area or motions for summary judgment or motions in limine or case specific, but if you're getting a case like in the one that I talked about from Oklahoma, a criminal defense case, and you don't know anything about the criminal law, you can't really bill to get caught up to speed on something that anyone who will practice in that area knows. So, I do, malpractice defense and tort defense. I can't spend time researching duty, breach, causation, and damage issues, right? So I guess it's kind of a yes and no, right? If it's basic stuff, no. If it's very case specific and it's a summary judgment or motions in limine, of course, that's case specific.
Yeah, Erik, I couldn't agree with you more. In fact, it's fun when Erik and I do this presentation, we always try to find some cases that are great examples of what not to do. And I know Erik talked about a few of those in the beginning of the presentation, but there was one that I had read. It's a few years old, but it was out of Massachusetts. I think it was called The Matter of Fordham. But the lawyer spent something crazy like over 200 hours and charged the client, I think it was over $50,000 for a very simple first offense DUI case. So the lawyer argued, hey, I was only charging $200 an hour. That's absolutely reasonable. There were no issues of false billing. This should be legitimate. And the court said, absolutely not. You charged over $50,000 for a case that should have been a quarter of that. And the lawyer said, yeah, but I admit that I had lack of experience in handling these type of cases. This deficiency prompted me to spend a lot of hours educating myself, but I didn't do anything wrong with billing because my rates were, they were reasonable, and this is exactly how much time I spent. And the court said, absolutely not. You can't pay yourself for learning on the job, even if the hourly rate is reasonable. So I think this is a good example of how Rule 1.5a works, because this wasn't something so egregious that the firm or the lawyer was charging for bathroom breaks, which is another case that we have seen that actually happened. But this is one where they were charging a reasonable hourly rate, but they were just charging way too much for a very simple case where a typical lawyer practicing in that jurisdiction would have charged less than half of that. So just another good example of how these rules really work in real cases.
If you bill by the hour, what is the recommended unit to use? Are there any ethical concerns about billing in 0.25-hour increments?
Sure, Erin, I'll take this one too, at least in the beginning. Okay. I think the standard of care in the industry is 0.1. If a client agrees to a 0.25, you can probably do it with the caveat of, I think it does create some ethical issues, because if you charge someone 15 minutes to do something that takes a minute or 2 minutes or 3 minutes, I think that creates some ethical issues. And I'd also be a little concerned if you're on a case where any fee award needs to be approved by a court, because my hunch tells me that a court reviewing 0.25 entries on things that turn out to be much less are probably not going to sign off on those fees and will probably deem them to be unreasonable. So I think the best practice, and actually the standard of care, is to bill by 0.1 increments.
Yeah, and I would just add to that by saying, of course, you want to outline anything in your fee agreement, right? I have certainly seen firms bill in 15-minute increments, but you want to think of the optics again. If a client is reviewing your bill and they see that you charge them 15 minutes for leaving a voicemail where you didn't even have a conversation with them, but you charge them 15 minutes for leaving a 10-second voicemail, it's not going to look good. So I agree with Erik. I think that charging in the 0.1 increments is probably the best thing to do. You can certainly outline something else in your fee agreement, but always think of the optics, because that's a really important piece of it.
Another question that just came in, is it okay to charge for initial consults?
Yes, I think it is. You're permitted to charge for the initial consult, as long as the client is aware of it, right? And again, it's explained to them. And a lot of times, I think practically, most attorneys who charge for the initial consultation fee, it's probably collected right there on the spot beforehand. So yes, like with most things, as long as the client is aware and agrees to it, it is something that you can do.
Okay, great. We'll take one more since we're over the time now. Should you reduce a bill to get paid?
I can jump in first if you want me. Go ahead, Erik. Go ahead. I'll follow you.
Okay, yeah, I think both myself and Erin kind of talked about this with respect to getting bills paid. I think it certainly is something that can be done. I think it's probably better to try to maybe do it on the front end, right? Like I talked about earlier, giving a Small percentage reduction if it's paid within 30 days. But at the end of the day, it's, if you're at the end of the case and months into an overdue bill, you certainly are permitted to reduce it in order to get paid. But I think the better practice is probably try to do it on the front end and build in the incentive to the client to pay earlier if you take a 2 or whatever percentage decrease off of the bill if you pay within a certain amount of time. So short answer to your question is yes, you are allowed to. Should you? I think the question says should. That's up to you, but I think best practice is try to build it in to the bill to get it paid earlier.
Yeah, and I would just add to that, Erik, I agree with everything that you said. But if you are going to give a discount, and I think I touched upon this towards the end of the presentation, make sure you're getting credit for any discounts. Even if you had talked about this beforehand, I think it only makes you look good that you're offering something like this. So if you choose to give any discounts for paying your bill within the first 30 days or whatever it may be, whatever you decide to do, just make sure you're getting a little credit for that and that the client's aware that you're offering this discount. And that's not something that all firms do. So whenever there's a chance to make yourself look good, I think certainly seize the opportunity.
On behalf of Attorney Protective, I would like to thank all of you for joining us for today's webinar. I would also like to thank our speakers, Erik and Erin. Thanks so much. Have a great day.